Hello friends, Namaskaram, how are you? Today I am going to discuss an important topic concerning the anticipatory bail in special offences, the offences in which the Prevention of Corruption Act might be a subject. Got the point now? So here and after I am going to discuss certain facts which are required to be borne by you in your mind while moving for anticipatory bail or regular bail in the cases concerned with Prevention of Corruption Act. Friends, my entire content is based on judgment of Honorable Punjab and Haryana High Court that is pronounced on 30th of August 2024. The case title is Usha Rani versus State of Haryana. In this case, the concerned accused had moved or inter alia submitted to the concerned court. Submitted to the concerned court means the concerned trial court for seeking the anticipatory bail. As we know that the provision concerning the anticipatory bail is inter alia incorporated in section 438 of CRPC. Inter alia, the bail application has been rejected. The concerned lady means the petitioner or the appellant had moved to the concerned high court for seeking the anticipatory bail. She submitted that the entire FIR is nothing but the abuse of process of law. So whenever you are going to argue an anticipatory bail, you must be very much clear that the allegations are false, and apart from that there is no prima facie case, complaint is not reasonable, it is totally concocted, and you are falsely implicated. These are the basic criteria which are required to be argued before the court of law to make the application maintainable. It is not the matter of course. Just to inter alia take 3 or 4 papers, narrate the manner in which you like. Always remember that when we are going to argue before the court of law and seeking the remedy, we must be clear that the type of remedy and the nature of concerned remedy available in the statutory book. Anticipatory bail means the allegations are false and the concerned IO inter alia want to book you in the present false case without any fault of you. Got the point now? The primary allegation against the concerned petition is that the FIR has been registered on the ground that certain accounts were opened in the post office, and the concerned petitioner is the agent, and the concerned party means the victim has deposited the amount of rupees 22 lakhs. The allegation is that the agent, by having hand in glove or by having conspiracy with the officials of the post office, misappropriated 22 lakhs at the inception, and finally the matter has been registered, and inter alia they committed forgery in consequence of conspiracy. So FIR was registered as per section 420, 467, 468, 471, 120B of IPC. And as we know that when the public servants are involved and huge loss has been caused to the concerned institution and to the concerned victim who are the customer or client of the institution, in that scenario section 7A and 131D of PC Act is also imposed with section 201 of the IPC. The concerned FIR is registered on the basis that the record of account had been obtained, and after doing the proper scrutiny it has been found that certain manipulations has been done. Apart from that, the signature of the concerned victim means complainant was totally mismatched. That is also important point, and the same is sustained by the CFSL report, and the report is also obtained in the due course. And apart from that, the transaction detail has been taken and emphasis has also been done regarding the same, and at the cost of repetition I want to submit that along with IPC section PC Act has been involved so that the proper action could be taken against the culprit and they could be put behind the bars. That was the basic intent of the concerned prosecution. And to prevent the escape of the concerned culprit, approval of section 17A of PC Act has been taken, and at the inception Mr. Roshan Lal, who is one of the prime accused, has been arrested, and after arrest he confessed that the crime has been committed by Mr. Joginder @Johnny, and he was also arrested one day after, and he confessed that he is son of the concerned petitioner, means Usha Rani. His father, his mother and wife are the post office agent. They used to visit the post office because they used to do the work on commission based, and apart from that they are having certain passbook of post office and stamp so that they could utilize same and could commit the crime. So in the entire scam the money was embezzled, and apart from that they were conspired, and in addition to this multiple FIRs has been registered against them. It is also evident from the record, and in that scenario a big scam of rupees 12 crore has been done. In the present case at hand, the allegation of concerned prosecution is that huge financial loss has been caused because they inter alia personate the concerned innocent persons, cheated them, and on the basis of false personification, they entirely created new ID and embezzled the amount given to them for the purpose of deposition. So basically, it is a breach of fiduciary relationship that has been between the concerned agent and the concerned victim. And in addition to this, there are 25 complaints more, as I told you earlier, which are under investigation. So in that scenario, the matter is critical, serious economic offense has been committed, so they never deserves the remedy of bail. The concerned petitioner argued certain points before the court of law, and the concerned petitioner's argument is that she is not involved in the present crime, and apart from that, there is no allegation to support the said substance, and confessional statement cannot be the basis for the prosecution or proceeding against the petitioner. And apart from that, she duly cooperated with the concerned investigation. She submitted the proof also. And in the counter, the court, when raised the query, the state submitted that the custodial interrogation is not required, but as the crime is very much serious, so benefit of bail should not be inclined to the concerned petitioner. So court, by looking to the fact, circumstances and the specific role assigned to the concerned petitioner, came to the conclusion that she has been robbed in the present case on the basis of confessional statement of the concerned co-accused. As we know that the co-accused confessional statement cannot be the basis for the prosecution, and apart from that, the bail remedy cannot be inclined merely on the ground that there is a confessional statement. Apart from that, there might be a huge loss, but all these facts are requiring the proper trial so that the guilt could be found out. And apart from that, on the basis of evidence so collected, it could not be said that the concerned petitioner is involved or she has done any forgery or cheating. And apart from that, as per the version of the concerned state agency, when the custodial interrogation is not required, in that scenario, the concerned accused deserves the benefit of bail, and bail remedy could be inclined accordingly. But while inclining the remedy, the court imposed certain conditions, not only on the concerned petitioner but also on the concerned police as well. She was required to submit the phone number, the email ID, the passport copy, and the Aadhaar number, so that the credential of her could be verified and she could be bounded not to leave the concerned place without the prior permission of the authority or court. And apart from that, she was ready to join the investigation, and for the same, Section 27 of Indian Evidence Act would be active. It was mentioned in the consent order, and if she fails to cooperate in that scenario, the concerned agency would be at liberty to move for cancellation of bail. But the point is that the cooperation does not mean the concerned lady or the petitioner could be compelled to give the evidence against her, or that comes within the purview of incrimination. Only those evidence can be allowed to be collected which are genuine and which are not against the test of Article 20 subclause 1, 20 subclause 2 of Constitution of India. If it is going to be hit the concerned petitioner right, in that scenario the evidences ipso facto would be inadmissible, and in that scenario the concerned prosecution agency would not be at a position to seek the liberty for cancellation of bail. But apart from that, the concerned three conditions had been imposed on agency as well. Number one, they will not use any third degree treatment. Number two, they will not use any indecent language. Number three, they will not treat the concerned petitioner with inhuman treatment. So looking to the fact, circumstances, the remedy has been given, and finally the concerned accused was given the remedy of anticipatory bail. So the said judgment inter alia provided us the remedy in following 5 ways. Number one, when we are going to plan for anticipatory bail, I am not asking for regular bail, because in regular bail you are in the confinement. But in anticipatory bail, you seek the remedy on the ground that the case is false, and in the present false case, the concerned IO is going to arrest you. So while arguing the anticipatory bail, you must satisfy to the court that the case is false. Until and unless you are able to do the same, you could not be in a position to get the remedy from the concerned court. Number two, the point of custodial interrogation is quite important. And point number three is that the role assigned to you and the counter argument on the part of the same. Number four, even though the monetary loss has been caused, even though there are evidences, but the key point is that the evidences cannot be presumed to be true during the course of investigation. Simply, you have to convince to the concerned court that if the court thinks fit while including the remedy of bail, the court may impose certain conditions. And I observed in multiple cases, specifically in MP High Court, Rajasthan High Court, the court used to impose condition that you deposit certain money with the court or with the police or with the complainant so that you could seek the remedy of bail, and this option is also important, and you may avail the same to seek the bail remedy. And apart from that, when the bail is given to you, you join the investigation. No third degree, no indecent language, no inhuman treatment can be done with you. If it is going to be done with you, you may report the concerned matter to the concerned court by the virtue of citation of Honorable Supreme Court, that is 2016 SCC page number 277. So follow this guideline, no need to be very. But before moving, think on the side versions, factual scenario, legal scenario, so that you could get the optimum result from the court of law.